yeah, surprising to have another copyright seminar within 1 week of the last one. I'll be saturating you in my little area of the law. Now, it was originally going to be just about the US case against Led Zeppelin, where it was alleged that their song Stairway to Heaven was infringing copyright, and a song put together by an old US band called Spirit. However, I've sort of broadened it out from that and of doing lots of comparisons with New Zealand law. So you're going to be getting US law, then New Zealand law. So we'll be going around in circles a little bit. Let's just see how we go. And I should say that the Led Zeppelin Stairway to Heaven song is 8 minutes long, and the copyright issues are all over the first 2 minutes only. Now, these are the opening bars of Stairway to Heaven. And now, that in addition to the acoustic guitar, a couple of recorders come in there to give it a sort of a medieval sound. That's what they're hoping. So I don't need to play any more of this now because I was playing it before, but this is the starting part, and that's the only part we're really considering in this case. Stop that. Right. Let's well, there's a photograph of two of the Led Zeppelin players, with Robert Plant, the singer, on the left, and Jimmy Page, the lead guitar. Jimmy Page wrote the music, and Robert Plant wrote the lyrics. Well, before we go too far, let's just have a look at copyright history and where music sneaks into copyright history. And here I'm looking at it from a sort of a UK global view, because the UK had the world's very first Copyright Act, as you can see there, way back in 1710. It only covered writings back in those days, but courts started including music or compositions within writings, you know, about 60, 70 years later. And then in 1842, those who held copyright in music were given a new right, the right to sue for unauthorized performances. That meant that musicians had to pay them a license fee to do a performance at a concert or something. And then still, before 1900, you know, the Berne International Copyright Convention came into being. What a lot of signatories. It was really generated by France and the UK. All of the top known countries except the United States signed up. And it meant that if you're in Britain and you produced some music, the music was sold in France and sold without a license, or copied there without a license, then the French courts would give you the benefits of national law of France in your suit against whoever was infringing. But the British Copyright Act as such didn't even exist then. There were lots and lots of different acts, all separate, giving different subject matter, different protection, and so forth. Well, finally, the whole lot was put together in one integrated act in 1911. And not surprisingly, New Zealand adopted that act in 1913. Australia did it in 1912. But the interesting thing about it was it was catching up with technology, and the copyright was conferred for the first time in sound recordings. So not just the music as it was sheet music written down back in those days when most music was written down, There's also a copyright in the recording itself. So if anyone mechanically, back in those days, that's what they said, not electronically or digitally, anyone mechanically copied the sound recording, then that was an infringement of whoever owned the sound recording copyright. And of course, as today, it was normally the recording company. Well, now let's have a look at the US music copyright history. You see their first Copyright Act, 1790, quite a long time ago. No copyright in musical works at that point, and you see they got added a bit later, 1831. And then their public performance right came about for musicians in 1856, but only applied to US citizens back then. And so Gilbert and Sullivan's operettas and so forth were freely plagiarized in the US. Gilbert and Sullivan got no royalties for that because the US wouldn't acknowledge copyright for UK citizens. But in 1891, the US finally changed that, but they still didn't want to sign up to the Berne Copyright Convention. They posted a law which allowed the president to initiate and sign up to bilateral treaties with other countries. So they do it sort of one by one. I'll have to say that France and Britain were the first two that they signed bilateral treaties with. So at long last, a British music composer had enforceable copyright in the US, except they had to correspond and comply with US formalities. That means they had to register their copyright, had to deposit copies of their music with the Copyright Office, and then they had to apply copyright notices. All the old style American stuff was put in place way back then. Now, whoops, jumped ahead too fast there. Finally, in 1909, the Copyright Act came along to replace the 1709 one. That took a long time, didn't it? But nevertheless, it still didn't include sound recordings, and they weren't protected until the 1971 amendment of the old 1909 Act. And that only applied to sound recordings made after 1972. So there's an awful lot of sound recordings made in America and all around the world before 1972, still after that amendment had no protection under US law. Finally, another new act, 1976 Act, which is, you might call, the current act now, although there have been a number of amendments. Finally, they got around to ratifying the Berne Copyright Convention 103 years after it was inaugurated. Now, just a quick reminder of copyright that can apply to what we might call music. So musical compositions, that's what we've been talking about so far. And in general, worldwide now, doesn't matter whether music was written in the form of sheet music or simply just played and recorded. And then you have separate copyright in the lyrics of a song. That is, for all those who followed the British model, and lyrics are protected as if they were a literary work. And the intriguing thing is, because whoever wrote the lyrics might not have been the same as whoever wrote the music, the copyright in the lyrics might last for a different period of time. Remember, life of author, plus 50 years here, or plus 70 years, most cases overseas these days. But the US did it slightly differently, and lyrics were integrated with the music, and there was just a single musical work which protected both the lyrics and the music. It's a little bit different from us. And then finally, there's copyright in sound recordings. Now, some background to the Led Zeppelin case. it's inspired all my mutterings here. A guy called Randy Wolf composed a song. It was an instrumental piece for his band called Spirit in 1967, and dutifully filed for registration at the Copyright Office and deposited one sheet of written music. Now, Led Zeppelin's Jimmy Page and Robert Plant started writing Stairway to Heaven in 1970, with Page writing the music and Plant writing the lyrics. And it took them a while to decide that they'd got it right. And they played it at a concert in 71 and released a recording, or rather it was an album, of which Stairway to Heaven was one track. And this, of course, is an old vinyl LP back then. And then Randy Wolf died in 1997, having never complained about Led Zeppelin's Stairway to Heaven in relation to his instrumental Taurus. But in 2014, trustee of Wolf's estate sued Led Zeppelin and commenced this legal action. And 43 years after Stairway to Heaven had been released. So there we had the 1971 release on an LP of Stairway to Heaven, and what permitted Skidmore, the trustee, for Wolf to be able to go to court in 2014 was that the US Act gave a limited period to sue after infringement, 3 years. And the thing that allowed him to sue for infringement in 2014 was that Jimmy Page put together a high resolution CD based on the master tapes of Stairway to Heaven and other of their songs. And the release of that CD triggered another 3-year period to run, so that gave Skidmore, the trustee, the chance to sue for infringement. So the case started in 2014, first trial 2016 in the District Court, California. There's a federal court, District Court of the Federal Court. And as many will have forgotten, in America, you have to have a jury. Unlike just confining juries to criminal trials in New Zealand, every trial over there has to have a jury, and so this one certainly did. And so the jury listens to all the arguments and the evidence. And the evidence in this case, of course, included expert musicologists representing each side. And before they retired to consider their verdicts, they were given lengthy written instructions by the judge as to how to interpret the law and apply it, so forth. Well, the jury came back and said no infringement. Now, in 2018, Skidmore went to the Ninth Circuit Appeals Court. That's the appeals court that covers all of the western states of the USA, not to mention Hawaii and Alaska as well, but based in San Francisco. And one of his complaints was that the judge hadn't allowed the jury to hear a recording of Taurus to make a comparison with Stairway to Heaven, and a number of other jury instructions that were given. Skidmore appealed against. The 3-judge panel of the appeals court said yes, a retrial with the jury allowed to listen to a recording. Well, Led Zeppelin went back to the Court of Appeal and successfully had an 11-judge panel of the Court of Appeal put together who accepted their appeal against the previous 3-judge panel and agreed to hear the whole thing again, virtually. And yes, well, that's sort of the emblem of the Ninth Circuit. What it actually means, and who put it together, and who's represented sitting in the middle of it, I have no idea. Maybe someone who's interested in these historical things could dig out the answer. Well, anyway, the 9th of March this year, the appeals court came out with its decision. And for those of you who are females, the judge who wrote the decision for the court was a female. Well, they said, we uphold the district court decision, no infringement. But the important thing was the 1909 Act applied and not the 1976 Act, which would never have happened in New Zealand because we have transitionary provisions, so that in most cases the 1994 Act would apply back to something that happened, say, in 1971. They didn't do that under American copyright legislation. The 1909 Act had to be dug out again, and of course, when it came out, there was no contemplation of having a recording, and in those days, the Copyright Office, you just had to file the sheet music to get registration and copyright. And that meant, of course, that the expert evidence was pretty important. The appeals court found the jury was right to favour the Zeppelin's expert witness. And then, and this will all be a bit of a mystery to those of you who haven't read the case, and New Zealanders in general, but not to Californians. One criticism that Skidmore alleged of the court below was that the jury was not instructed about the Ninth Circuit inverse ratio rule. Well, he didn't get too far with the appeals court. Oops, I'll get rid of that stuff. The court not only said, well, that wasn't wrong on part of the judge, our old rule, inverse ratio rule, which I'll explain in a minute, was wrong, and they struck it out. Let's get back into the 1909 Act. The problem was current 1996 Act wasn't enforced when Taurus was written. And as I said, no transitory provisions. So the previous Act still applied to a lot of music written before the 76 Act came into force, which is 78. And I said all those formalities were required. And that led the appeals court to say, right, well, the music to which Stairway to Heaven is to be judged against is the sheet music which was deposited at the Copyright Office. This upset trustee for Wolf and the Spirit Band. They wanted recordings, their recordings, to be heard, because, as it turned out, the recordings that they released actually had a few more embellishments added over and above the sheet music at the Copyright Office, which perhaps increased the similarity with Stairway to Heaven. But anyway, they were denied getting that heard. Now, as to deciding whether or not the district court had sort of got all the elements of infringement correct and the jury had correctly applied them, the appeals court went through these established principles in the Ninth Circuit and, for many of them, the rest of the USA as well. And they said, right, first requirement must be proof of copying. And when they said copying there, they meant what we would call causal connection. there couldn't be some independent creation which turned out to be similar, had to be proper copying. So, yep, similar to us. And then next step, unlawful appropriation, not a term we sort of use. Our equivalent to that is objective similarity, where the judge himself in New Zealand can conduct that test alone sometimes by just visually or using his ears or her ears to make a comparison. But in the Ninth Circuit, in our case here, non-expert jurors, non-expert in music, had to rely quite heavy on the expert witnesses' evidence from both sides and then assess which they thought was correct. And I should say that they liked the idea of Led Zepp's expert witness, who said the similarity between the two pieces, or the first 2 minutes, was no more similar than the words crab and absent are similar. The only similarity being in those two words, the letters A, B. They said that was about the similarity between Stairway to Heaven and Taurus. Well, over in the US, in addition to that, they have, for the substantial similarities test, there are actually 2 sub-tests, and the other sub-test is non-expert test. So that if the jury was to say, right, there is objective similarity, they then have to move on to the non-expert test. And that is forgetting about the expert witnesses' evidence and just themselves as non-experts assess whether they thought there was similarities. Now, we don't, of course, have non-expert tests in New Zealand. In this case, they didn't go to this second sub-test. And that was another criticism of Skidmore. But as the appeals court said, these are like hurdles. You didn't get past the first hurdle, objective similarity, because the jury said there wasn't one. If that's the case, you don't need to move on and apply a non-expert test as well. So quite similar to New Zealand, except because we have this third little bit tacked onto ours, the substantial part test. Has there at least been a substantial part of the work which has been copied? And they don't actually isolate that out separately in the US. Now, getting back to the so-called Ninth Circuit inverse ratio rule, where the judge was criticised by Skidmore for not having instructed the jury on. And it went like this. It said, first of all, you don't look at substantial similarity first. You look at this sort of what we call causal link, copying. And if, there's lots of good stuff in there indicating that there could be copying, usually there's never any direct evidence, of course, then if that's the case, then the rigor of the test of substantial similarity is decreased. And so if there looks to be a nice causal link there, you don't have to worry about too much how similar the two works are. Well, in theory, of course, we don't have that in New Zealand. But surprisingly over there, and that was a doctrine of the Ninth Circuit itself, the 11-judge panel said that was rightly not included in the jury instructions. And in fact, they abrogated that inverse ratio rule, threw it right out, saying, and I quoted there, not part of the statute, defies logic and creates uncertainty. So in that respect, for people litigating over in the Ninth Circuit, the law has changed a bit because that old inverse ratio rules been biffed out. And they did also take the view that on the evidence, there wasn't high sort of proof that Jimmy Page of Led Zepp had actually accessed Taurus. It was just a mere possibility of access and no more. So the court felt sort of quite happy about their conclusions on that inverse ratio issue. Well, let's now sort of move sideways and come back to New Zealand with that inverse ratio rule still kept in mind. And if we look at the Supreme Court's decision in Ankle and Holdfast, there we have the judge who wrote the judgment for the court, saying the ultimate issue in a breach of copyright case concerns derivation, not similarity. And as I'll mention shortly, in my view, it's total nonsense. And in fact, that is a version of the inverse ratio rule that the Ninth Circuit Court has just thrown out. Because the ultimate issue is derivation, not similarity. And when you read a little bit more of Tipping's judgment, you can see he sort of was bending towards the Ninth Circuit inverse ratio rule. That if it was thought that there was contact between the defendants and the original work in some way, then similarity is less important. And that's sort of what Tipping was saying there. Wrongly, in my view. Even wrong in the Ninth Circuit, the US right now. And one of my problems is that it can lead courts to merge ideas with expression when you do that sort of thing. You know, because it's minimizing similarity, maximizing possible causal connection. But when you're doing that and not maximizing similarity tests, you can think that the idea has been copied and say that copyright has been infringed there. And really need similarity assessment, which is based on the expression of the work, based on what you see through your eyes or hear through your ears. That in itself can screen out ideas. And we notice that the Sealegs case, the High Court got it a bit wrong there, and really, just like the old US doctrine we were talking about, was really looking at copying of ideas and not confining themselves to expression. But fortunately, Justice Brown on the Court of Appeal, when the case went there, corrected that. Now, in an older case, way back in 1995, the Court of Appeal there in New Zealand had expressly rejected the idea that strong evidence of causal link could impact in any way on assessing objective similarity. They made it abundantly clear. Why our Supreme Court years later dived off in a different direction, I do not know. Now, of course, courts first have to consider whether the work is entitled to copyright. That is, does it have originality? Particularly, of course, when the defendant raises that. But here's what the Ninth Circuit Appeals Court sort of said about when you're dealing with music, and in particular pop songs. You know, they say many, if not most, bear some similarity to some prior song. And then frequently you have a selection and arrangement of unprotected elements. And of course, there's sufficient originality in the selection and arrangement. Never mind that there was nothing original in the building blocks. And in America, they like using the word building blocks as little bits, to refer to little bits of music that have been used off and on by all sorts of composers for a couple of centuries. And Justice Cole, in our most recent music copyright case, 8 Mile Style case against the National Party, she was saying similar sorts of things. Individual component parts may be borrowed from other songs and individually may be unremarkable. However, it is a result of the elements being combined to create a new work, which is the issue. So we've got some similarity there between New Zealand and the Ninth Circuit. Now let's go back to the sort of fundamentals of UK New Zealand case law in determining infringement. And we decided in our first design copyright cases, and fundamentally, when you get down to it, when you're getting down to basic principles like the test for infringement, there's not a lot of difference between assessing infringement of design copyright than music copyright. Well, in 1963, the UK Court of Appeal established tests which were adopted in the UK and in New Zealand and Australia. In this Francis Day and Hunter and Bron case, Francis Day and Hunter was a music publisher. And here they are. There must be sufficient similarity between the two works. So similarity assessment comes first, and a causal connection comes second. And then they say that similarity is an objective issue, and that's why in New Zealand we've been calling it objective similarity for many years. And they say the causal connection is a subjective issue. And then a substantial degree of objective similarity, being the first test, may be prima facie evidence of causal connection. You know, it's just so similar that surely it couldn't have been conceived independently. But then they also said mere proof of possible access to the plaintiff's work by the defendant does not in itself constitute proof of causal connection. And interesting, that's almost exactly what the Ninth Circuit case said about Jimmy Page when he admitted he actually owned a copy of the Taurus LP. And Francis Day and Hunter said there's also there may be subconscious copying. And that Francis Day and Hunter case was a music copyright case. And in fact, at the end of the day, the court said that there was infringement and the causal connection was subconscious copying. And in New Zealand courts have applied these for many years, followed by late 70s, 80s cases. We went through those tests sort of religiously. No one dared to suggest, and no court ever mixed them up and turned them upside down. But things have changed a bit in the last 10 years. Now, if we just sort of sidestep and go back to our music case, 8 Mile Style, it's the National Party and Justice Cole. And this is where, as a reminder to you, that the National Party used M&esque music as background music for a TV ad. And that was written by a guy called Michael Cohen. And one of the big issues was, well, did Cohen's M&esque infringe Eminem's Lose Yourself? Because that was the original work the plaintiffs were relying on. And of course, the plaintiffs in that case said there was infringement by the National Party because they had communicated the infringement, which was a copy, they claimed, of Lose Yourself. Of course, the National Party didn't reproduce it because it wasn't them that made the copy themselves, it was them that communicated. But again, Justice Cole did adopt, at least in a broad manner, the Francis Day and Hunter test. And looking at objective similarity, she thought that a non-expert such as herself was the right person to assess objective similarity. And of course, as we heard, as you heard a little while ago, that was a second sub-test in the Ninth Circuit. And we don't sort of recognise that as a sub-test or anything, but just as a reasonable thing to do when assessing similarity in New Zealand. The other difference here is that in the 8 Mile Style case, the judge, no jury of course, could listen to recordings and not have to be relying on experts explaining what's in written sheet music. And that all sort of comes out of the fact that Section 15 now says copyright subsists in musical works as soon as they are recorded in writing or otherwise. And the or otherwise, of course, is a standard sound recording. And so copyright immediately subsists there, and that sound recording can be used for assessing infringement, even though, of course, the copyright in the sound recording would actually be owned by the recording company. Well, I have many issues with the Supreme Court and Nickel and Holdfast, but here's another one. In assessing infringement, they decided that, okay, we've looked at the plaintiff's work, we now look at the defendant's work. And if we think it's of sufficient originality to amount to a copyright work itself, then there will be no infringement. Well, that's a bit mad. Apart from many cases in New Zealand and UK saying that the super adding of ingenuity makes something original, to do that after undertaking robbery, it is robbery nonetheless. But never mind that, we just need to have a look at other case law and the Act itself, and just look at the example of translations. Say a English translation of a German novel. The translations are original and attract copyright, but that doesn't save them from infringing the original work. They need to get a license to make the translation, otherwise it's still an infringement. And that's a direct opposite to what the Supreme Court said in Henkel. Now I'm sort of saying that, well, we never went wrong with all the real old cases, which the highest court they all went to was the Court of Appeal. And here's another reason why I'm saying they're right and the Supreme Court wrong. Look at that case, 1989. And I should say that former partner AJ Parks was the late Tom Galt. He was acting in that particular case. They nicely adopted Francis Day and Hunter rules: objective similarity, causal connection, and said they were specifically in that order. In fact, Justice Summers said these were hurdles, and if the plaintiff couldn't get over the first hurdle, the second was irrelevant and assessment stopped. So objective similarity was primary, not causal connection, as the Supreme Court somehow said years later. And if there's no objective similarity, you didn't need to go any further. You didn't even need to look at causal connection. That's what Summers said, using this hurdle analogy. Well, that's it. I won't bore you stiff by going on about more criticisms I have of the Supreme Court, so we better finish it there. And questions now, if Alex can unmute people.
There are no questions in chat, so if anyone's got one, just chuck it in and I'll read it out.
I should say that there's a very tiny chance that there will be an appeal to the US Supreme Court. I'm sure they want to appeal, but it's generally thought that this sort of case doesn't have the sort of the issues that a Supreme Court would accept that it needed to make a decision on. So it probably is the end of the matter in the Stairway to Heaven case. Perhaps I should also mention something else too, in that if you could have copyright, say literary copyright, in 3 words, another party might have had to go at Led Zeppelin, because Stairway to Heaven was actually the name of a song in the early 60s, written and sung by a guy called Neil Sedaka. But the music was different, and all of the lyrics, apart from his title, were different. But it's just intriguing that you had those 2 songs with the same name a couple of decades apart. Well, I'll play some more music.
So it doesn't look like there's any questions, but EMS, Dan Hearn, Matt Adams, APB, MCH, Catherine Starkliff all say thanks.
Okay.
There's a lady who's sure all that glitters is gold, and she's buying a stairway.
We've got singer started, but the music underneath them is still a continuation of what
stores are all
start.
closed with a word she can get,
But then it pops up a bit later.
and she's buying a stairway. There's a sign on the wall, but she wants to be sure, 'cause you know sometimes words have two meanings. In a tree by the brook, there's a songbird who sings. Sometimes all of our thoughts are misgiven.
Looks like most people are starting to leave, so I will end it for now. Thank you everyone for watching.
In my thoughts I have seen